Hi, my name is Carl Pearson. I'm a foreclosure defense attorney and want to explain what I find to be the best defense for most homeowners against foreclosure lawsuits. I've decided to do a video on this topic because I see that too many homeowners are failing to use this number one defense, resulting in the loss of their homes or the receipt of unaffordable loan modification agreements which have the same result later on in many cases. For you to understand how to use this number one defense, which I call reverse dual tracking, you have to understand what dual tracking has come to mean. Before the federal government and the 50 state attorneys general got involved, the banks, trusts, and loan servicers, which I'll now simply refer to as the major banks or just banks, were widely engaged in dual tracking as the way of separating homeowners from their mortgaged homes. More than 100 predatory loan practices by the banks were involved and identified. Banks would require a homeowner to go into default before they would even consider looking at a loan modification application, so that when homeowners made their application, they were necessarily in default and the bank had the immediate right to foreclose. Instead of foreclosing right away, the banks permitted the homeowners to keep sending additional documents to the bank to supposedly update the applications. The bank hired thousands of persons in India to review these pending but not yet fully submitted applications to see what else could be demanded of the homeowners, for the purpose of never permitting the application to be marked completed, so that the application, hopefully from the bank's standpoint, never got to the bank for true consideration on its merits. By this time, often several years of being jerked around, the applications became stale in the lender's opinion, or the homeowners just gave up and provided no more of the requested additional documentation. And the banks then marked on their records that the homeowner didn't want a loan modification because he or she didn't complete his or her application to the minute extent improperly demanded by the banks. All during this time, the homeowner was on the foreclosure track, or you might say that the homeowner is being railroaded into foreclosure, with a law firm representing the bank in a foreclosure action against the homeowner or an action that has been threatened to be commenced. The loan modification activity was a second track involving communications directly with the bank and its Indian employees, kept separate and apart from the foreclosure track, which was handled for the banks by attorneys and law firms who seldom were kept abreast of what was happening with the loan modification track, with the homeowners being on both tracks but only dealing with the loan modification track and usually doing nothing to protect themselves on the foreclosure track. These two tracks operated parallel to and independently of each other for the most part, resulting in no modification for the loan modification track and a foreclosure of the property as to the foreclosure track. In addition to lacking the money to pay for needed legal services, most homeowners thought that since the banks seemed willing to give them a loan modification agreement and in fact had told them to stop paying the mortgage and go into default, the bank might look adversely upon their application if the homeowner did anything at all to defend the simultaneous foreclosure action. And homeowners often reason, why waste the money if they're going to give me a loan mod anyway? What homeowners didn't know is that the banks statistically, or as a practical matter in all too many instances, were not going to give the needed loan modification, and by inducing the homeowner to stop paying his or her mortgage to qualify for making the application, the banks were giving themselves the option to foreclose and sell the property through the default in the foreclosure action, and because the homeowner in fact was in default in paying the mortgage. And in too many cases the banks did exactly this. We call this dual tracking, where the bank fights the homeowner on two separate parallel tracks, the loan modification application and the foreclosure action, with the homeowner failing to defend on the foreclosure track and being denied an affordable loan modification agreement on the loan modification track. Now, let's talk about turning this situation around into the homeowner's best defense. There are various ways in which homeowners try to defend themselves against foreclosure. and rather than listing all of the different types of professionals and other individuals involved, I will merely say that most of them are not defending on both tracks properly, and many of them do not even purport to defend on one or both of the tracks. In order to defend on both tracks properly in what I am calling the reverse dual tracking defense, you need first of all to have a knowledgeable foreclosure defense attorney defending against the foreclosure track. Most persons involved in loan modification work are not mortgage defense attorneys. Most foreclosure attorneys, on the other hand, have not yet acquired the necessary expertise in pursuing the loan modification track, especially with the permissible interplay under various laws and rules with the foreclosure track. For the best foreclosure defense, you need to have vigorous prosecution of foreclosure defense along both tracks by persons who know how to do this. The foreclosure track requires an attorney, whereas the loan modification track requires the second team member, a loan processor experienced in pursuing loan modification applications, to comply with a myriad of rules and regulations created by the banks, as well as some governmental agencies and some statutes. The loan processor processes the application to comply with all the laws and rules that the bank is required to follow, in many cases under present law, to provide the loan modification with the appropriate interplay and guidance from the attorney working as a team for the homeowners. The problem I have seen over the past years since 2008 is that homeowners who start out on the wrong foreclosure defense team, with the wrong foreclosure defense team, too often wind up with threatened loss of their home when this could have been avoided by the first attorney making use of the dual track principles I discussed above. A good loan processor usually knows when the homeowner's application entitles the homeowner to a loan modification and can spot and deal with mistakes made by the bank when processing the application, which often occurs when the bank denies an application or fails to have its loan modification offer in the appropriate monthly amount and with the appropriate principal amount. A competent, experienced loan processor knows how to obtain remedies outside of the existing lawsuit and pursues such remedies as the loan modification track, somewhat independently of the attorney's activities in defending the foreclosure track. The attorney, at the same time, as a team, defends the foreclosure action initially by trying to obtain a loan modification using the litigation tools available to the attorney, including mediation and finding and pursuing bad faith dealings by the bank and its attorneys through motions and bad faith hearings where these are permitted by law. It should be noted that the attorney and loan processor are dealing with the same loan modification application, which generally is given initially to the bank's attorneys and hopefully, raising various good faith issues, is then turned over by the bank's attorneys to the bank, but sometimes is not. And that's where the issues may arise. The defense team challenges the bank by the attorney through the courts, the foreclosure track, and by the loan processor through regulatory agencies and other venues, the loan modification track. It is this concerted team effort in identifying and benefiting from errors and weaknesses by the banks and the bank's attorneys' dealings with the loan and the loan modification application, something usually occurring during a stipulated period at the beginning of a foreclosure action, that often causes the bank to give an affordable loan modification just to end the dual track trouble being given to them. But if this activity does not take place at the beginning of the foreclosure action because of an inadequate or unknowing defense team, you cannot go back in time in the lawsuit by hiring a different attorney and loan processor. The courts do not allow you to back up the litigation and start all over again. Yet for those homeowners who have no other choice, this is often what I am asked to do, which is more costly, more difficult, more time-consuming, and less likely to achieve the desired results, and in many cases will result in a waste of the new attorney's time and a further waste of the homeowner's money. I am saying all of this to get to the point of this video, which is that homeowners facing a foreclosure action need to bring in the best team, attorney and loan processor, from the very start to have the best opportunity for saving their home at the least cost. The reverse dual track defense, when commenced at the outset of a foreclosure action, has many opportunities during the litigation to compel the bank to stop the defense by granting a loan modification agreement, even if the homeowner doesn't qualify for a HAP modification, and even if the case has been lost on appeal. But to get the full benefit of the defense, you have to start at the outset of the foreclosure action, including the preparation, servicing, and filing of a timely answer to the foreclosure complaint, alleging a variety of defenses and possible counterclaims for use later on in the action. If you are facing foreclosure anywhere in New York State, I am able to handle the matter directly. If the foreclosure is outside of New York State, I can work with a lawyer in your state to provide the dual track defense for your foreclosure. Failure to use this reverse dual track defense at the outset of the foreclosure action inevitably, for most homeowners, results in a loss of the right to maintain such defense, even if the homeowner and his or her attorney were unaware of what needed to be done. The courts seldom allow a litigant to back up and start all over again with an appropriate attorney and previously unused defenses. What this comes down to is this: if you are facing foreclosure, you have a better chance of saving your home through an affordable loan modification agreement if at the outset you retain an attorney who knows how to and actually uses this reverse dual track defense. They don't have to know what I call this defense, that is the reverse dual track defense, but they should be able at least to explain how they propose to defend you on both tracks and who is going to do it. The skills of the people involved in defending you should be of the utmost interest to you. If they don't have the skills to do what is needed to be done, probability is that it won't get done or won't get done properly. When this happens from the outset, the rest of your case will probably be prejudiced because the belated hiring of an appropriate defense team usually cannot restore the rights you have lost to defend your foreclosure with a dual track defense. For homeowners in non-judicial foreclosure states, there is also a dual track defense, which I will describe to you if you email your request to me at carlpurse2@gmail.com. Also, I invite questions from homeowners in judicial foreclosure states. I look forward to hearing from you.